Sensenbrenner Hall, and more specifically in this great room, longtime Grimmelsman Courtroom, and now Eisenberg Room. It is my privilege as Dean to welcome all of you to this, our annual Hallows Lecture. This lecture stands in memory of E. Harold Hallows, a member of the Wisconsin Supreme Court from 1958 to 1974, and Chief Justice during the last 6 of those years. That is an impressive run on a state Supreme Court. But it is not all that moved the law school to create this Hallows Lecture. For E. Harold Hallows was, for an even much longer time, a professor here at Marquette University Law School. For 28 years, from 1930, the year that he graduated from the University of Chicago Law School, to 1958, the year that he was appointed to the court, he was Professor Hallows. Professor Hallows taught a generation or more of Marquette law students courses such as Equity and Equity 2, even as he practiced law in Milwaukee and helped to lead various law reform efforts. In short, E. Harold Hallows was a practitioner and a professor of energy and distinction even before his service as a justice. How appropriate then that more than a decade ago, the law school determined to create this annual opportunity in Chief Justice Hallows' memory for a distinguished jurist to spend a day or two within the law school community. Truly, the Hallows Lecture is a centerpiece of our academic year. This year, today, we are privileged to have with us, as our Hallows lecturer, the Honorable Mark Filip. He is formerly a judge of the United States District Court for the Northern District of Illinois, a position to which he was nominated and unanimously confirmed in 2004 at age 37. Judge Filip served in that position for 4 years until in the final year or so of the Bush administration, the President and the new Attorney General, the Honorable Michael Mukasey, asked Judge Filip to resign from the bench in order that he might serve as Deputy Attorney General, the number 2 position in the United States Department of Justice. To this position as well, Judge Filip was unanimously confirmed by the United States Senate. Upon the conclusion last year of his term as Deputy Attorney General, Judge Filip returned to private practice, as had been his pursuit between his service as an Assistant United States Attorney in Chicago in the late 1990s and his service as a judge. Today, he is a partner at Kirkland & Ellis. There is so much more about Judge Filip's background that is of interest. He is a former instructor at the law schools of the University of Chicago and Northwestern University, a former Marshall Scholar at Oxford University, a former law clerk to Justice Antonin Scalia of the United States Supreme Court, a graduate at the top of his class of Harvard Law School, and for all of this, perhaps, if I know Mark, most proud to be a graduate of the University of Illinois. But it is not ultimately these things that commend him to us today. It is rather what brings him to Milwaukee and its law school, Marquette University Law School, and that is to deliver our Hallows Lecture entitled Federal Criminal Law, Some Possible Reforms. Please join me in welcoming the Honorable Mark Filip.
Thanks a lot. I'm very honored to speak here at Marquette today, particularly at a lecture in honor of Chief Justice Hallows. Marquette is, of course, a Jesuit institution, and thus guided by the famous Jesuit admonition, ad maiorem Dei gloriam, for the greater glory of God, is part of the great teaching of Jesuit institutions, so welcoming and inspiring to people of all faiths, that our work here on earth is not simply for the pursuit of money or some vain quest for the pursuit of power or glory, but rather should properly be directed to trying to make our world a better place for all of God's children. Harold Hallows, in all the various spheres that Dean Kearney just recounted, spent his life doing exactly that. So this is indeed an honor. My topic in this Hallows lecture is the current state of federal criminal law, or at least a few important topics in it. Before I get to the specifics, let me please speak for a moment about the general. Please know that I will concentrate my comments on the federal criminal justice system. This is not on account of the relative importance of it in relation to state systems, but primarily because the federal system is the system that I know best. Also, let me please acknowledge up front at least a few of my potential biases. First, on the pro-government side, please know that I have enormous regard for the men and women of the U.S. Department of Justice, including the attorneys, the administrative staff members, and the brave men and women who serve in enforcement agencies here and abroad, agencies like the FBI and the DEA and the U.S. Marshal Service. I don't think I'll be pulling any punches because of that affection, but I should acknowledge it. At the same time, I now work as a practicing attorney, and at times that involves representing clients who are involved in issues with the federal government. I don't think I'll be pulling any punches or shading any views on that basis either, but again, you should know the facts so you can be critical listeners. Finally, by way of background, you probably should know that I think a foundational reason our federal criminal justice system works is because we typically have various checks and balances in the system, such that the various actors, including prosecutors and defense attorneys, have the ability to help deter overreaching by any others. This is not to say that such overreaching is particularly common in practice. It typically is not. But the reason people tend to walk a true line and that the system maintains overall balance and integrity is that the checks and balances are there to promote keeping everyone on path. That balance is a fundamental guarantor of our freedoms. So, proceeding to the specifics, let me please speak first to an issue, a nascent issue. It's created by the growing use of business concepts in assessing whether government enforcement efforts, including criminal prosecutive efforts, are successful or worthwhile. I respectfully suggest that while accountability in government is critical, including for law enforcement agencies, using business concepts too fastly creates dangerous incentives that do not benefit the law enforcement system or society as a whole. Let me please explain. To begin, what do I mean by the use of business concepts in assessing the worthiness of government law enforcement efforts? An example is the growing use of the idea of quote-unquote return on investment for law enforcement expenditures, which is a phrase one sees often in my experience in Washington, D.C., in executive branch and congressional budgeting decisions. Analysts talk of return on investment for budget expenditures, and law enforcement officials from some entities argue that their enforcement effort is worthy, and often worthy of greater funding and priority, because for every dollar spent on a particular sort of enforcement, say certain types of fraud enforcement, we had a $17 return on investment, or a 13-to-1 return on investment. A related theme is that of advocating success from increased numbers of arrests or convictions or lengths of prison terms or dollars of fines from this year over last. In my experience, this sort of analysis is most prevalent in enforcement agencies outside of the Department of Justice. Perhaps that's because other agencies typically run more like business entities, albeit sometimes inefficient ones. Perhaps it's because the Justice Department is very much a multi-mission agency, whereas some other enforcers are single-mission agencies, or perhaps there's some other reason. But in any event, my basic argument is that this mode of thinking and analysis carries substantial dangers that at a minimum must be appreciated and guarded against. Within this first large point, let's start, please, with the idea that success is fairly inferred by the fact that the numbers of arrests or convictions or the average length of prison terms is higher this year than last. The greatest danger with this analysis is that law enforcement is not like a business, where one can fairly conclude that if profits are up, the world today, as compared to last year, is a better place for relevant constituencies like shareholders and company employees. Law enforcement is different. It's not reasonable to think that, God willing, if we prosecutors just keep at this long enough, our arrests and convictions will keep going up, with the unspoken logical implication being that eventually everyone except us will be in jail, and won't that be a great result? I don't mean to insult anyone's intelligence by suggesting that my former colleagues in law enforcement think everyone should be in jail. Most people in law enforcement are sober and balanced people who make great sacrifices to help make real the idea of a free society that